The Guide to Unreasonable Search and Seizure. The Fourth Amendment to the U.S. Constitution protects against unreasonable government searches and seizures. If the police violate your Fourth Amendment rights while investigating or arresting you, you may be able to have illegally obtained evidence excluded from court. Here's a quick guide. What is the definition of search and seizure? A search is defined as any time an agent of the government interferes with an individual's reasonable expectation of privacy, generally by searching their property, body, or home. A seizure can refer to either the seizure of a person or a seizure of property. A seizure of a person is defined as when a police officer's conduct would communicate to a reasonable person that they are not free to leave. For a person to be seized, the police officer must show authority through handcuffs, physical contact, a firearm, or verbal command, and the person must submit to that authority. A seizure of property is defined as when a government actor meaningfully interferes with a person's possessory interest in their property. What is unreasonable search and seizure? Reasonableness is considered to be the primary test of whether a search or seizure is constitutional. If a search or seizure is conducted without a warrant, it is presumed to be unreasonable unless it falls within a few exceptions. The most obvious exception is if the police officer feels that the suspect may have access to a weapon. When determining whether a warrantless search or seizure was justified, a court will balance the amount the search or seizure intruded on the person's right to privacy with the government interest advanced by conducting the search or seizure without first obtaining that warrant. What's an example of search and seizure? Some common examples of a search include pat-downs, searches of your body or clothing, searches of your vehicle, searches of your home or rental property, searches of a bag, luggage, or another container in your possession, drug dog sniff inspections, or even electronic surveillance. Some common examples of a seizure include arrests, a traffic stop, investigative detention, or confiscating personal property. What is a search and seizure amendment? The Fourth Amendment to the U.S. Constitution, which is part of the Bill of Rights, requires searches and seizures conducted by the government to be reasonable. The Constitution is such a great document because it allows us to reflect on the history of our country. The Fourth Amendment was placed in the Constitution because the Americans wanted to guard against government oppression. They did not want to allow the government to just walk into your house and start searching around. They wanted protection from unreasonable governmental power over their autonomy. What violates the Fourth Amendment? Some examples of searches and seizures that are considered to be Fourth Amendment violations include detaining someone without a reasonable, articulable suspicion of criminal activity, arresting someone without probable cause, or searching a vehicle without probable cause to believe it contains evidence of some sort of criminal activity, conducting a traffic stop without a reasonable, articulable suspicion of a traffic violation, or setting up a highway checkpoint program with the primary purpose to discover illegal drugs. Do I need a criminal defense attorney near me? If you've been charged with a crime, you should contact a criminal defense attorney as soon as you can. An experienced lawyer can evaluate the circumstances surrounding any searches and seizures that occurred during the investigation and arrest process to determine whether any potential Fourth Amendment violations occurred. Call or email anytime. At Attorney911, we defend people like you every day, and we sincerely want to hear your story. Thank you for watching.